Yes, Mr. Theodore.
Thank you for that. I think just before the break, my lords, we were looking at 2039.
Yes.
And we were considering section 16.
16.
The question was, what happens if, and it was a very hypothetical question, what happens if there is a 1-year-old squatter? He's been squatting for a year. What is supposed to happen in such a case? He would not satisfy 16(1)(a), which requires his possession to have been of a sufficient quality for a period of 30 years. However, he may fall under 1D, which reads, if the recording officer is satisfied that a person is in possession of or has a right to a parcel, but is not satisfied that such person is entitled to be recorded under paragraph A of this subsection as the owner of the parcel with absolute title, the recording officer may nevertheless record that person as the owner of the parcel. So in theory, it is if nobody else claims, a 1-year squatter in theory could find himself under 16(1)(d). In that case, he gets provisional title. There shall be a record made of the date on which his possession started under D1. D2, particulars of any deed, instrument, or other document by virtue of which any right or interest adverse to or in derogation of the title of that person might exist. So reference there to the paper title owner and any other qualification which affects the title. So that would be the position in the event that there was a single claim. There's the title, the paper owner did not make a claim.
But suppose the paper owner does make a claim.
If he does make a claim, then we turn to section 15.
All right.
If he does make a claim, we go to section 15 of the Act, which requires the recording officer to refer the matter to the adjudication officer, who shall adjudicate upon and determine any dispute. So 15(1)(b) says, if in any case there are 2 or more claimants to any interest in land, and the recording officer is unable to effect agreement between them, the demarcation officer or the recording officer, as the case may be, shall refer the matter to the adjudication officer. So that would be the position if, in fact, there were 2 claimants, the title holder and somebody who claims on the basis of long possession. So that would be the position under the Act.
Mr. Theodore, under English law, the commencement of an adverse claim by the paper title owner would stop time running in favour of the squatter. And therefore, if the squatter hadn't by the start of the proceedings been there for the requisite period, the paper owner would win.
Yes.
And is that what would happen under...
That's exactly what would happen. That's exactly what, once there is the dispute, and you go in, and you are going up against the paper title holder, and you have not satisfied the requirements of the Civil Code in terms of the quality and the period of your prescription, the adjudication officer would have awarded title to the paper title holder.
So the running of time is stopped, is it, by what? The making of a claim under the Adjudication Act to the adjudicator? Because normally it would be a claim in court, although court proceedings here are stayed, as we know.
Yes. In practice, what happened was you would physically go to the office of the LRTP and make that claim. And that claim would be recorded in the office.
And that would stop time running, would it? And that's
It wouldn't. I wouldn't say that it would stop time running, because it simply meant that if you had made a claim, the position would then be: is there another claim that is going to be made? In which case, there is going to be an adjudication hearing, or if there is no other claim, then we go on to consider D.
Sorry, I may not have made my question clear.
Yes.
Is the making of a claim adverse to the squatter by the paper title holder to the adjudicator enough to stop the paper title holders running? I'm supposing it was 29 years in, and the squatter was within a year of getting his full 30 years. What in this situation would the paper title holder be able to do to stop him getting his full 30 years thereafter?
Under the Civil Code, a judicial demand would stop the prescription.
Right.
So in other words, he would file and serve a claim.
But you can't here file a civil claim because they're stayed.
Yes.
So my question is, would filing an adjudication claim have the same effect and constitute a judicial demand under the Civil Code?
That's a very interesting question, and I don't know the answer to that. It actually
Most
never.
grateful for any help I can give.
that I can't remember that ever coming up.
I'm just looking to try to see how this would work out in practice.
Yes, my lord. Okay.
Anyway, don't let me take you out of your course.
The only point that my learned friend is suggesting is that the mere fact that the courts have recognized that there is a quasi-judicial element to the process, it might very well be that it may be interpreted as being sufficient to stop title running when the Civil Code speaks of a judicial demand served upon the person. So if I may quickly continue, because I think I only have...
Before we move from section 60, what is the effect of provisional title? Does that give you title against the whole world, save anyone that comes forward with a better claim to the land?
Exactly, my lord.
Right.
And what would have happened is, after 12 years, you would have a right to apply for the conversion of your provisional title to absolute title.
So there can only ever be one provisional title on the register?
Absolutely, my lord.
Right.
And provisional title is always geared to adverse possession. There are no other types.
I must say, I can't recall a title holder being given a provisional title. We have come across that? Yeah. And it would have been absolute under 16A.
Or if there is someone acquiring rights by adverse possession, you say
there will be
trigger the dispute mechanism
under section 15,
and then that is resolved at that point in time.
Indeed, my lord.
But under 16(1)(d), the words "or has a right to a parcel" apply to someone who's not in possession, because it's in possession of or has a right to a parcel. So it's difficult to think of anybody other than a paper title holder who would have that right, isn't it?
Well, on an intestacy, you might
Or
have...
maybe somebody are taken by way of transmission.
Yeah.
Yes, that would be a
But
possibility.
ultimately, their transmission right would depend upon their predecessor's paper title.
Indeed.
And can you get a case of a contest between paper titles? So two people coming
Oh
forward?
yes, we had many of them.
So would that be covered by the words "or has a right to a parcel" in section 16(1)(d)?
16(1)(d). Yes, I believe so, my lord. Yes.
Okay.
If the recording officer is satisfied that a person is in possession of or has a right to a parcel, but is not satisfied, certainly that would fall there.
And then
At some stage, could we have the part of the civil code that deals with a judicial demand interrupting, stopping time from running?
Yeah.
I would like to actually see the civil code that deals with that at some stage, not now. But
Very well, my lord. With the part of the code dealing with the judicial demand interrupting prescription.
So therefore, whether a quasi-judicial
Yes.
process would fall within that part of the civil code.
Very well.
It is to be noted that the stay in section, whatever it is subject to the consent of the adjudication officer permitting a civil proceeding to be started. So you might apply to say, well, I'd like to start proceedings and then stay them for this purpose. I've forgotten which section it is, but.
Yes, in fact, I do actually remember one case in which we made an application to stay the LRTP. Well, in that case, it was because we had ongoing proceedings which had started before the LRTP. But it certainly can be used in a situation where you have an interest in having the prescription interrupted.
Is it section 7.1?
yeah, page 2025.
Yeah.
Yes, if I may continue in the interest of time. In addition to the points that I've just made in relation to 8 and 16 of the LAA, the Court of Appeal, rightly, in my respectful submission, held at EB Electronic Bundle 971 that the scheme of the LAA and its operational connectivity with the LRA clearly contemplate that a person who claims to own land, including an overriding interest under sections 23B, 27, and 28F and G, must have signified that interest during the LRTP pursuant to section 6 of the LA and 8 by making a claim in the prescribed manner. In relation to the second key submission of my learned friend, there is no need for the period before first registration to be excluded when reckoning time. Our answer is that it is necessary for the period before first registration to be excluded because on the authority of Joseph and Francois, which is at 2431 of the bundle, the LRTP, by the conjoint effect of the LAA and the LRA, provided an entirely new, all-embracing and comprehensive scheme designed to adjudicate upon and provide registered title to all lands in St. Lucia. And your Lordships must pardon me if I keep harking back to the quasi-judicial nature of the process, because that is what has led in large measure to the interpretation that the Court of St. Lucia has placed on the statutory scheme. We have seen the position under Section 88, where registered title could be obtained not only based on documentary title, but also by possessory title. And that's important because the other side has relied on the Graham Davis matter from Antigua, where the powers of the adjudication officer were considerably curtailed. And in fact, he could not award title based on a claim for long possession if someone with registered title also appears before him. And that is the fundamental difference. The fundamental difference. Our scheme allowed the adjudication officer to make rulings based on possessory title, even to defeat a title of a documentary title holder. It was a holistic scheme implemented for the purpose, and that is critical, for the purpose of bringing certainty to the ownership and identification of lands in St. Lucia. And this can be found at Matty, Joseph and Matty, at 2432 of the electronic bundle. Also in the decision of the board in Richardson at 2454 of the bundle. The purpose of the scheme was to bring certainty to the ownership and identification of lands in St. Lucia. All persons claiming interests, including overriding interests, were required to advance their claims. And again, that is critical. Even if you were there in possession for 5 years, you had the right to advance your claim. And if there is no title holder, you will actually get provisional title. In this case, the appellants were claiming to have been in possession for over 100 years. It is true that the Court of Appeal has found that their possession only goes back to 1976 by the undated Augustine survey. But at the time, they were claiming, well, they've claimed many things. They claim to be the title holders. They also claim to be in possession for over 100 years. But at the end of the day, on the basis of either of those claims, they ought to have made a claim to the LRTP, and Section 8 mandated it.
So a person who had a short lease not exceeding 2 years would require to make a claim, is that right?
Absolutely, my
And
lord.
if they didn't, that would be their lease.
There would be a danger of losing it. Just as persons who had documentary title, who didn't make a claim, risk losing their title. And in fact, it happened quite often. And it is to be noted that in the Lucia matter, the board, in fact, endorsed what it called the judge-made law, which is that it is a mistake in the registration process. Although these words are not used in the Act, it must be a mistake in the registration process that can entitle you for relief under Section 98, dealing with rectification on the ground of mistake or fraud.
And
the board has
I missed the name of the case and the reference.
Sylvina Louisiane.
Oh, that's the Privy Council.
That's the Privy Council case, yes, my lord, which my learned friend referred to. In that case, the board referred to the cases which I referred to in my skeleton, where I attempted to give the history of the interpretation of the statutory scheme. The board in Louisiana accepted that it was correct to impose, as it were, the interpretation that it must be a mistake in the registration process. So in other words, mistakes in the adjudication process could not be raised under Section 98, with the result that persons who simply sat back, had perfect documentary title, would have lost it. The question arises, on what basis? Is there a principal basis on which we can say that a squatter should be in a better position? Since Skelton, the courts have held that if you didn't make a claim, you can't, and you did not appeal, you didn't follow the rules set out in the LEA and the LRA, you would lose your title. I find it difficult to believe that a squatter should be in a better position than someone with documented title.
Could you help me with the 28E, and that is unpaid money, which is expressly declared by any law to be a charge upon land. It's page 2055. What rights are we considering there?
That, I believe, has always been taken to be a reference to a part of the Civil Code which stipulates that judgments, for example, constitute charges against all property held by the judgment debtor. All property. So in other words, even if you, for example, had a mortgage with a particular bank, and the bank were to proceed to actually enforce the security and get judgment against you, that judgment would in fact be a charge over every single piece of property that the judgment debtor owns. So a judgment in St. Lucia creates a charge over all property. So that is why, in fact, in practice, although the legislation requires us not to look anywhere else, because of that provision, our courts have held that you would be reckless not to actually consider the registration of deeds and mortgages registry, where these claims and judgment debts are registered. So whenever there is a judgment registered in the High Court, for example, it would be recorded in the Registry of Deeds and Mortgages, and you'd be required to go there. So that is what we have always accepted to this particular subsection to be referring to, charges.
Would it cover deposit of title deeds to secure a loan?
The mere deposit of the title deed?
Yes.
I would not, I don't think it does.
Okay.
It is actually the judgment that would create. Now, it's also a conventional hypothec may be created actually by the mortgage instrument between the mortgagee and the mortgagor. So that would also create a charge.
But this is expressly declared by any
law. Yes. So that is different. Yes. So that would definitely be a judgment creates a charge.
Would you be able to let us have the section in the
Absolutely.
code which does that, please?
So you have to make a search even after this land registration process has come into force?
It still continued to operate side by side with it.
Because it's an overriding interest?
Because it's an overriding interest. The reason, my lords, why our courts have given the interpretation that they have to the LAA and the LRA is that it simply would not make sense. In fact, the judge at first instance used even stronger language. He said it would make complete nonsense of the process and defeat the intention of the LRTP to now ground a claim in prescription when the very LRTP provided an avenue for such a claim to have been made and awarded.
That's paragraph 26 of Joseph.
Yes, and actually in the court below, the Court of Appeal at 192 accepted and gave, impliedly accepted the...
Is that paragraph 192?
Paragraph 192, which is at EB, at electronic bundle 974, my lord.
Thank you.
So we say that the clear language of the LAA and the LRA, and we've referred to the sections, coupled with the laudable objective of limiting matters that erode indefeasibility, and I'm referring specifically to British American Cattle at 2176, where the board accepted that the aim of the torrent system, the ultimate aim, is to limit as far as possible matters that erode indefeasibility. My learned friend in that regard submitted that while that may be a laudable objective, it wasn't practical because it could never be achieved. And my learned friend referred to a case, but I would respectfully submit that that case actually pointed out that an acceptable exception was in relation to fraud and mistake, which is under Section 98. My learned friend also submitted that rights acquired by prescription may be used as a shield against a claim by the paper owner, notwithstanding sections 94 to 95 of the LRA. We say in St. Lucia, due to the judicial or quasi-judicial nature of the adjudication process, during which claims were required to be made regarding prescription rights acquired or in the course of being acquired, had the effect of interrupting prescription. However, rights which were acquired after first registration may, however, be set up as a shield against the registered proprietor. And my learned friend correctly pointed out that the Court of Appeal seemed to accept that, but simply formed the view that the requisite period and quality, well, certainly the requisite period had not been made out in this case. But I believe that both the judge at first instance and the Court of Appeal clearly accepted that it is possible to raise prescription as a shield, notwithstanding the absence of a certificate.
But if you're in that sort of situation, why couldn't you raise it as a sword as well? I mean, why couldn't you, let's say 35 years after the coming into effect of the new scheme, and you've got your 30 years prescription, not go to the registrar and say, I've acquired now full title by prescription, please put me on the register as proprietor?
There's nothing to prevent you from doing that.
Okay.
There's nothing to prevent you from making the application. If you think that post first registration, and in fact, the registration in St. Lucia pretty much ended in 1987, so we have 30 years between then and now. You certainly could go to the registrar now and say, post-registration, I have in fact accrued 30 years.
And why not go to the court?
Previously, we would have gone to the court, but Plan Byron has resulted in the Court of Appeal saying that the court does not have the jurisdiction because the Land Registration Act specifically vests that jurisdiction in the registrar.
And what's the right of appeal then, from the registrar to the court?
To the court.
And is there another right of appeal to the Court of Appeal after that?
Indeed, yes, Miller, there always would be. You would go to the High Court, then to the Court of Appeal. And that is why the Court of Appeal is saying it's rather incongruous for us to be responsible for awarding title when in fact the Act makes provision for us to perform in a supervisory capacity.
And does the High Court act in a fact-finding role on such an appeal? or is it confined, or are his powers confined on an appeal?
It does not have a fact-finding role, no, my lord. If I may now quickly pass on to the other submissions made by my learned friend. I don't think there's anything I need to say anymore about section 6 and 8. However, I do want to say quickly in relation to section 9 of the LAA, which is at 2026. My respectful submission is that that section sought to safeguard the rights of persons who had claims but failed to make them. And I think it strengthens the point that because the process was intended to be complete and final, we didn't want to have straggling claims because persons, in fact, had claims and ought to have made them. So that section clearly gave the power to adjudicate upon the rights of persons who didn't even make claims. My learned friend has submitted that far from the submission that there is a need to bring a claim, the sections 23 and 28 clearly show that that is not necessary. And I would keep harking back to the quasi-judicial nature, because that is really an understanding of that particular principle is what is actually fundamental to an understanding of where it is that the Court of Appeal is actually coming from in relation to this case and others like it. It is because of the quasi-judicial nature of our adjudication process and when we read, as Louisian said we should, the LAA and the LRA as one interlocking machinery, we are obliged to accept that section 6 and 8 are sufficient to provide the express statutory mandate for the bringing of a claim. My learned friend has submitted that the effect of the Court of Appeal's interpretation is to deprive individuals of their rights, which are expressly recognized by the statutory scheme as overriding interests without compensation. we say that it serves the public interest for there to be finality to the adjudication process and certainty in the St. Lucia torrent system. And that is achieved by limiting the matters which undermine the indefeasibility of registered title. All that the court has really done in this case is to extend to overriding interests a principle which the court has consistently applied since the case of Skelton, which is that if you failed to make use of the statutory machinery which required you to claim, required you to appeal if you claimed and you lost, if you failed to make use of that machinery and you allowed the deadlines set under the LAA to expire, then you risk losing everything. The appellants submit.
So just on that, presumably that's subject to Section 9 of the LAA.
Section 9 of the LAA is the one that says even those who have not made claims,
there's a discretion.
There's a discretion.
I think you would say the discretion has to be exercised in light of the underlying principles of the system. So you need a very good reason for not having brought your claim. Is that right?
Absolutely, Miller. Absolutely. At the time, though, of the LRTP, it would have been perfectly fine for the for the adjudication officer to make a determination that, looking at all of the documentary titles which others have produced, it's clear to me that this person actually has a claim which they ought to have made. And if, in fact, the adjudication officer or the recording officer were to, based on that information, were to award or decide to make an entry in the adjudication record to that person, then there would be no question that there was a claim which ought to have made. So in other words, the position is that if you didn't make a claim, or if it happened that the LRTP didn't realize that there was a claim that you could have made and did not in fact address it, then you risk losing everything.
And that will include a claim to a provisional title, will it?
Absolutely, my lord. A provisional title. In other words, as we have seen, if you're claiming on the basis of long possession, but in fact you are the only person claiming, but you don't quite meet the requirements of 16(1)(a), then you would be awarded with provisional title, because there's nobody else with better title. And you would have to, essentially 12 years for anybody else to come and challenge your title. After 12 years, there is the provision to apply to convert your provisional title to absolute title.
And what's that provision? Don't take up the time now, but if at some stage.
Yes, we will get that provision.
Mr. Theodore, just a reflection on your obviously correct point that more than 30 years have now passed since the land adjudication process. Looking with the benefit of that 30 years of hindsight, the supposed policy objective of construing the legislation in the way that you do is putting a sort of stop on the running of time.
Yes.
At the time of the adjudication process, has really only produced, on one view, a sort of temporary advantage in terms of certainty, because now 30 years has passed, we're back to square one, aren't we?
That is so, Millard, but at the end of the day, I think we've seen the authorities suggesting that it is very important not to turn persons away who have, in fact, genuinely prescribed.
Yeah.
So I think even the torrent system certainly carves out a niche for them, and that is, in fact, so it really, the position of the appellants that there is, by the interpretation placed by the Court of Appeal, and a certain degree of unfairness, that is certainly to be weighed against the fact that, as your Lordship has just pointed out, that would only apply only in relation to the time that would have passed before the LRTP. You're perfectly entitled to continue in your possession, and if you had, and if there had been no judicial demand, you would have been entitled to make a claim 30 years post first registration. My learned friend has submitted, my lords, that the interpretation placed by the appellants aligns with the board's decision in Graham Davies. We say that that case is distinguishable. The appellants say it is not because the scheme of the legislation in St. Lucia and Antigua were materially the same. We say that that submission is misguided. We accept that there are certainly points of similarity, but Section 15.2 of the LRA, which could be considered as the fulcrum on which rested the quasi-judicial nature of the adjudication process, differed markedly in the Antiguan Registered Land Act. And the critical difference was that in Antigua, the adjudicator was prohibited. He was prohibited from varying any interest in land registered under the Title by Registration Act. And he was required to simply carry forward any such interest to the new register, which was established under the 1975 Registered Land Act. And that is the crucial difference. It wasn't a full and complete quasi-judicial function that the adjudication officer was required to carry out in Antigua, because his hands were tied. In St. Lucia, unlike Antigua, it was that power of the adjudication officer to award title based on long possession during the LRTP, even against a paper owner, which created the much vaunted quasi-judicial adjudication process, which the courts have construed as interrupting prescription. A certificate holder was protected in Antigua by the legislation that required his title to be registered as the first proprietor, while at the same time preserving rights like prescriptive rights. No such carve-out provision existed in St. Lucia. And when our courts said that no such carve-out exception existed in St. Lucia, and this is at 966 of the electronic bundle, paragraph 175, our court wasn't saying that no carve-out provisions or exceptions to indefeasibility of title can be found in St. Lucia. The court wasn't saying that. It was merely saying that in St. Lucia, none of the exceptions that do exist under the LAA and the LRA, none of them is similar. there was no such provision which tied the hands of the adjudication officer. So it is correct that both the St. Lucian legislation and the Antiguan legislation provided an express carve-out to indefeasibility of title based on rights acquired by prescription, but in the case of St. Lucia, this did not apply to first registration due to the very same, and I will be repeating quasi-judicial nature very often, my lords, but it is that quasi-judicial nature which the board has recognized, which has made our process what it was, and made it different from what exists and existed in Antigua. The fact that no personal notice was given to those who might have overriding interests in both St. Lucia and Antigua.
I just wonder what the phrase quasi-judicial capacity comes from page 2538, and but why is it not in a judicial capacity? I mean, obviously it's not an ordinary judge, but why is it quasi-judicial? Isn't it determining things
Actually,
in a judicial capacity?
Actually, my lord, our Court of Appeal in Portland referred to it as a judicial process. However, the board in Louisiana used the phrase quasi-judicial. So it has been described as both a judicial and a quasi-judicial process.
Sorry, which was the other reference you said?
The Loopsome Portland matter, my lord. Let me see if I can get the page.
Is it Portland? It's not Portland. And
It is Loopsome Portland, yes, my lord.
That's the authority referred to in paragraph 40 of Louisiana. Is that right?
That is correct, my lord.
Okay, I'm sure we
Yes.
can find that for ourselves.
Yes. So the fact that there were some similarities between the legislation in Antigua and St. Lucia, namely that no personal notice was given, and a notice was merely required to be published in the Gazette and in a local newspaper. These certainly are points of similarity, but nothing turned on them in Lord Jauncey's decision. We submitted it was not merely that notices were given, but that under Section 8, everyone claiming an interest in land had an obligation to claim. The points of similarity were not sufficient to create for Antigua the quasi or fully judicial adjudication process, which in St. Lucia had the effect where that first registration interrupted prescription. So in other words, the mere fact that there was no requirement in both of them for there to be service, personal service on would-be claimants, is not critical. That similarity was not enough to create a judicial process. And that is why in St. Lucia, our adjudication process interrupted prescription, whereas it didn't in Antigua.
Can I ask, was there an equivalent in the Antiguan Act of Section 9 of the LAA, which is the safety valve if you don't make a claim at the appropriate time?
Yes, my lord.
There was?
There was.
Yes, and it was Section 9
Yes.
as well.
And my learned friend has submitted.
I mean, I think the acts, two acts, are virtually identical, with the exception of the proviso to which Lord Jauncey refers, to section 15.2.
I believe that is quite correct, my lord. And it is that section which created the critical distinction. The appellants submit that the Court of Appeal was wrong to assert that the legislation in Antigua and Barbuda was different, and that Lord Jauncey's reasoning turned on the fact that the scheme expressly preserved overriding interests, the presumed purpose of the scheme, including the lack of personal notice, the consequent unfairness for individuals who enjoyed overriding interests if those interests were to be defeated by registration. We say, and we're referring to 2309 to 2310, which is Graham Davies. The board's reasoning in that case turned on the fact that the scheme of the legislation was that an interest registered under the Title by Registration Act would be registered in the 1975 register without alteration, but that such registration would not affect the existence of overriding interests, such as rights acquired or in the course of being acquired. At 2310C, the board says, in their lordship's opinion, the proviso to section 15 left the adjudication officer with no alternative but to record that ownership of the bluff should be vested in the appellants. In so doing, he made no decision as to the validity of the disponee's counterclaim, leaving it to them to pursue their remedies through the courts. And that is fundamentally different from the position in St. Lucia. Under section 15, our adjudication officer would have been obliged to conduct a hearing to make a determination between the competing claims. But in Antigua, his hands were tied. And so it is not surprising that Lord Jauncey would, in those circumstances, say at 2310D, it follows that the respondents did not lose any overriding interests which they or their predecessors in title possessed at the date of the appellant's registration, and are in no way barred from seeking now to enforce those interests. Of course, the adjudication officer was merely required to record the title holder as the registered proprietor and leave it to the courts to later determine the rights, the competing rights between that title holder and the squatter. My learned friend submits that Lord Jauncey's reasoning did not depend on the fact that under section 15 in Antigua, the adjudication officer lacked the power to vary an interest in land registered under the Title by Registration Act 1887, and that Lord Jauncey only referred to that lack of power after he had concluded that overriding interests were protected without the need to bring a claim. The appellant submit that in making that reference, he was simply making the additional and subsidiary point that the respondent's failure to raise prescription during the LRTP was irrelevant, since the adjudication officer could not vary the registered title. We say the board in Graham Davies did not raise the adjudicator's lack of power as a subsidiary point. It was central to Lord Jauncey's reasoning.
But if you look at, I'm on page 2310, starting in the second line, this is an eminently logical approach, since many of the overriding interests detailed in section 28, and I think we can assume that section 28 was pretty well the same as
Ours, yes.
are of a character which might very well not be apparent to an officer visiting the land in the performance of his duties under the Land Adjudication Act, one would say, snap. It would be manifestly unfair that a person who would acquire or was in the process of acquiring an overriding interest in a parcel of land upon whom no specific notice had been served, snap, should forfeit such interest simply because he hadn't become aware of the publication of the statutory notice. It was no doubt one of the purposes of section 28 to avoid any such unfairness. So he's reading the purpose behind the preservation of overriding interests under the land registration part of the Antiguan legislation back into the land adjudication process, and saying that serves to deal with what would otherwise be the unfairness of this land adjudication process adversely affecting people who might well, with interests of that kind, not pick up what was going on. Now,
Indeed, Miller.
I don't see why any of that, which is, on one view, the central part of his reasoning, is actually affected by the question whether the adjudication officer could have done anything about it, even if somebody had popped up and said, I've got a possessory claim.
I think, Millard, what Lord Johnsey was doing was simply saying, given the legislation which I have before me, which is different from ours, given that legislation which I have before me, I can well see why it is that the legislators decided to remove the power from the adjudication officer, because I can see that it would be very easy, it would be difficult to be sure that there are persons who are in fact acquiring an interest. So he's saying this legislation, when it in fact removed the power from the adjudication officer, I think that was a good idea. But the point is, this is different from ours. Our legislation removed it.
But take a case where competing claimant to the land in the Antiguan situation hadn't got an earlier registered title. And I'm assuming that the reason for land adjudication in Antigua was because the previous Land Registration Act just hadn't been comprehensive enough.
Yes.
So there was still a lot of land that had never been registered. And so suppose you have a piece of land which has never been registered, in relation to which the adjudication officer wasn't debarred from being quasi-judicial by section 15.2, why would not the reasoning of Lord Jauncey that I've just drawn attention to apply with equal force?
I think the answer to that, Millard, is simply in the first place, Lord Jauncey's remarks cannot be applied to St. Lucia for the reason that I've stated. So we cannot rely on Graham Davies as authority in St. Lucia. What Lord Jauncey was simply doing was making the peripheral observation. It was not part of the ratio of the case.
Can I apply the reasoning to another part of section 28?
Yes,
and that is in relation to short leases, which seems to be dealt with as an overriding interest. That's a lease of 2 years or less.
2 years, yes.
Does the same eminently logical approach apply to that? Namely, that the officer visiting the land in the performance of his duties wouldn't be able to it wouldn't be apparent to him as whether the person in occupation was under a short lease or whether it was a family member or an employee or whatever it was, or was under a license.
Yes, it would be. I think there would be a similarity there, because such short leases would not normally be registered. Yeah. Yes, so it would be difficult to determine whether they exist.
And it would be manifestly unfair that a person who was in occupation under such a short lease, upon whom no specific notice had been served, should forfeit his interests. Does that logic also apply?
I think the answer to that, my lord, is simply that as I've said before, in St. Lucia, the provision was made, and it was made for a reason. That is, the curtailment of the power of the adjudication officer in Antigua specifically was made for a reason. Antigua is different as a result of that, and in the circumstances, the case of Graham, while it would have force in Antigua because of that curtailment, in St. Lucia, we just cannot apply it. I don't think that I can give any other answer but that, Miller.
Well, Section 15.2 wouldn't apply to the short lease, would it? The Antiguan Section 15.2 wouldn't apply to the short lease. It couldn't be the reason applicable to a short lease, could it?
Perhaps not, Millard. And I think that though we have to be careful, because in the case below, I don't think we have seen any authorities coming out of the OECS actually dealing with the point. So I would say that perhaps we should be careful to limit our inquiry to those cases which have dealt with the question of actual documentary title, the question of possessory title. In relation to leases, etc., we do not have any authority, and it may very well be that before we can make any pronouncements, it would require a deeper analysis into the authorities, perhaps in Australia and elsewhere.
But I thought you weren't making a pronouncement. You said that the short lessee lost his rights if he didn't make a claim. I thought that was a pronouncement.
Yes, well, it was a forced pronouncement, yes, Millard. I think that I was actually obliged to accept that on the wording of Section 28, that in fact might be the case.
Thank you.
My learned friend then submits that not only does Graham Davies support her case, but that it is consistent with George and Guy out of Dominica. We say, though, that George and Guy is also distinguishable in the first place. The Title by Registration Act in Dominica, and I'm referring to 965 to 966 of the electronic bundle, the TRA in Dominica identified fraud and supersession by a title acquired under the RPLA as the only two exceptions to indefeasibility of title granted under the TRA.
Sorry, could you just give that reference again?
965, my lord, to 966.
965.
Paragraph 169.
Thank you.
Thank you, my lord. And at 172, paragraph 172, page 964 of the bundle, in some Torrens enactments, like in St. Lucia, adverse possession is considered an overriding interest in land, whereas in Dominica, the legislation expressly states that adverse possession is an exception to indefeasibility. In Dominica, the RPLA disables the registered owner from further asserting ownership, and we can see that at 2203, paragraph 14 of the lead judgment in George and Guy, and contrast that with Articles 2048 and 2050 of our Civil Code, which illustrate that prescription, in fact, can be renounced. The reference to our Civil Code is at the very end of the bundle. That would be 2788. We say that Section 33 of the TRA provides a process whereby a person claiming to have acquired ownership of land by way of adverse possession, which brings me to the point, my learned friend made the point that adverse possession was pretty much identical to prescription under our Civil Code. I would just like to state that, in fact, that is not the case. The very articles which are set out at 2788 show what, in fact, is required for prescription. But we say that Section 33 in Dominica provided a process whereby a person claiming to have acquired ownership by way of adverse possession to apply to displace and cancel the title of the registered owner and be issued with a certificate of title cloaked with then identical indefeasibility of the original certificate. St. Lucia, Section 94, simply states that anyone who claims to have acquired land ownership by positive prescription may apply to the registrar for registration as proprietor. So they are not the same. The appellants argue in relation to Guy that in George and Guy, the appellant argued that although he could not maintain an action to assert ownership, he could resist the claim by raising his adverse possession as a defense, which is the 2198. And PCCJ Saunders held that given the exception to indefeasibility in respect of adverse possession, even if a squatter has not availed himself of the Section 33 procedure to acquire title, he could resist a court claim on the same basis by raising his adverse possession as a shield. And in the same way, my learned friend is now making what I would classify as an inductive leap. In the same way, the appellants argue, a person who has acquired rights by prescription is able to rely on those rights to resist a claim for possession, even though that individual has not made a claim during the adjudication process. We say the situations are entirely different. One, the requirement to claim under the LRTP was part and parcel of an adjudication process that was judicial or quasi-judicial in nature. As much cannot be said about the Section 33 procedure. Secondly, the legislation in Dominica did not impose an obligation on squatters to invoke Section 33. But St. Lucia's LAA imposed on squatters the obligation to bring claims. And many did, and they were awarded title on the basis of long possession. The appellants argue, relying on George and Guy, that Section 28F of our LRA outfits a party in the appellant's position with a shield that is effective against the registered proprietor and anyone else who is unable to demonstrate better title. We say in St. Lucia, due to the judicial or quasi-judicial nature of the adjudication process, during which claims were required to be made regarding prescription rights acquired or in the course of being acquired, first registration, as a result, interrupted prescription. However, rights acquired after that first registration may be set up as a shield against the registered proprietor. The distinction is, it is that process, that judicial process, which we would make nonsense of if we were to allow persons claiming on the basis of long possession to keep coming in, making claims on the basis that the first registration did not interrupt their prescription. There is an absolute need to bring about finality and certainty to our system. I would like to refer to 2383 at paragraph 41. That is the judgment of Chief Justice Pereira in the James and Clanviron case. That's 2383, paragraph 41.
2383.
2383,
Yes.
paragraph 41.
Yeah.
Thank you. Sorry.
There, the learned Chief Justice said, the instant case is not in the nature of a dispute as to ownership of the portion of parcel 743, as the very concept of prescription involves the recognition of the paper title owner against whom the person claiming is being said to have prescribed. Similarly, it is not a claim to possession, since the appellant is not asserting a claim as an owner seeking possession from some other person. Rather, he is seeking to be recognized as owner based on his own possession. A dispute as to ownership can result in a rectification of the land register in cases where fraud or mistake has been made out, either in respect of a first registration or a subsequent registration. In my view, therefore, the court retains some jurisdiction, albeit in a different form than that which arises from Article 2103A. So that is in relation to the jurisdiction point. This is the explanation given by the court in Clanviron. And again, at 42, the learned Chief Justice goes on in relation to section 80, which my learned friend referred to, and that is a section whose rubric starts off with transmission. The appellant has also prayed in aid section 80 of the LRA. This section has been set out in 15 above. He says that this section allows the registrar to act on the court's declaration of title. I respectfully disagree. This section, as the heading suggests, deals with the registration of ownership in land acquired by way of transmission. And transmission is defined in section 2 of the LRA to mean the passing of land, a lease, or a hypothec from one person to another by operation of law on death or insolvency or otherwise, and includes the compulsory acquisition of land under any written law. The provision also, so we go overleaf, provides for transmissions which may come about as a result of the court ordering a sale of land by way of enforcement of a judgment or a judicial sale allowed under the Civil Code and the Code of Civil Procedure. It is clear that Section 80 has nothing to do with rectification of the land register. It simply permits, quote, registration, unquote, as distinct from rectification of the land register. where the land in question has passed from one registered owner to a subsequent owner, which may be either the Crown or some other person, by operation of law on death or insolvency or otherwise, including compulsory acquisition by the Crown. And quickly, 43, a registration by virtue of a transmission is not in play here. The case is simply one of rectification pursuant to prescription rather than pursuant to a transmission. And that is why the Chief Justice held that, in fact, Section 80 was totally inapplicable. Indeed, there is no provision in the LRA which allows for rectification of the land register on the basis of a transmission. I have taken on board the observations made by this court in the case of David George and Albert Guy at paragraphs 22-24. These observations reinforce my view that the LRA must be construed in accordance with what it says. Part 9 and sections 97 and 98 of the LRA are clear and must be construed by according them their ordinary meaning. Moving on very quickly,
I'm not quite sure why, leaving aside the special meaning of the word transition in the heading to section, transmission in the heading to section, why it's wrong to describe a situation where a squatter has got up to 30 years as a situation where one person has become entitled under any law. I mean, on the face of it, until the 30-year goal deadline is reached, the paper title holder is the owner, and an application by the squatter for registration of the squatter as proprietor would fail. And then on the day when 30 years is passed, the title has become vested in him, subject to getting it himself registered. But why shouldn't Section 80 apply in that situation?
I believe that the distinction that the learned Chief Justice was drawing, and we can see it in the middle of paragraph 42, it is clear that Section 80 has nothing to do with rectification.
Well, no, I entirely accept that, but why is, in a situation where A is the paper title holder, B is squatting, and gets past the 30-year target date, why is B asking for rectification? He's not asking for the register to show that he was the proprietor at any earlier date. He's simply asking for it to be shown that he is now the proprietor. In just the same way as someone to whom the ownership of the land had passed by some other law, or by some order or certificate of sale or anything else.
I mean, isn't that indeed I might be reading this too quickly, but the point being made at the end of paragraph 42, it's not rectification, but you could have a claim for registration.
Yes.
It simply permits registration as distinct from rectification of the land register.
But
Yes.
so perhaps I'm losing the background here, but I thought what is happening is that you have got an absolute registration in place for this piece of land. Mm-hmm. And if you're going to replace that with one based on a possessory title, that necessarily is a rectification, isn't it? Because you remove the existing absolute title holder and you substitute the new one.
And that's exactly what the learned Chief Justice is saying, that the Act, Section 80 of the Act, simply permits registration as distinct from rectification.
I mean, we ought to note this is all part of Part 7. Mm-hmm. Starting at 2075, headed Transmissions and Trusts.
Yes.
And it's dealing with transmission on death, 76, 77, transmission on bankruptcy, 78, 79, liquidation, 80, compulsory purchase or judgment of the court, and then trusts. And survivors in 82. I mean, the context of this part does not seem to be the resolution of a dispute as to ownership between a paper title holder and a possessory title holder or alleged.
Most definitely not, Miller.
The difficulty I face is if you are allowed to raise prescription as a defence in court proceedings, and you're only allowed to go to the registrar in as a sword, you then have potential for conflicting decisions between two judicial proceedings.
It might very well be, my lord, that perhaps the logical thing might be that to construe Section 94 and 95 as in fact requiring, even in relation to using prescription as a sword and as a shield rather, that perhaps the logical thing might be to actually approach the registrar, although one wants to be careful not to overburden registrar with claims of this nature. But certainly I concede that there is a potential for some if I may, just in the interest of time, just wrap up. My learned friend refers and relies on the Strand Securities case, famous decision of Lord Denning. But we say that to rely on Strand Securities is to submit, in effect, that there may be some similarity between the LRA 1925, UK, and the legislative scheme of land registration in St. Lucia. The very idea that our civil system of immovable property is comparable to the English system of estates in land boggles the mind, quite frankly. At the very least, the appellant would have to show that there existed under the LRA 1925 in the UK a legislative scheme that created a quasi-judicial adjudication process that paralleled St. Lucia's. So we say that Strand Securities is entirely inapplicable. We wish to emphasize, my lords, that while it is true that at the time that this appeal was filed, our court had not in fact ruled, there was no judgment by our court in relation to overriding interests, and that has changed. And the case of Zimbani, which we've referred to in our bundle, clearly is a case which deals with overriding interests, and in that case, the ratio is that first registration interrupts prescription in relation to those overriding interests. Because my learned friend submits that, Zimbani is distinguishable, perhaps even per incuriam, because no mention was made in there of Graham Davies. The point that we make, though, is, as we have shown, Graham Davies is in fact distinguishable, and the mere fact that it was not mentioned wouldn't raise any red flags in relation to the principle which the courts have espoused in Zimbani. Finally, my learned friend has referred to a number of first instant decisions coming out of Belize and St. Lucia. I'm not quite sure what the real intention is, but I've noticed that in all of the claims, bar one, and that is the one that my learned friend was happy to point out that I was in it. All of them, bar that one, dealt with a situation where the overriding interests were created after first registration. The Edwards case, which is the case that I was in, was actually a case where the fourth defendant had acquired documentary title to the land from 1963, and with the advent of the LRTP, he never claimed, although he had been in possession in virtue of that title deed from 1963. So quite frankly, even the claimants were disposed to having the court find a way to assist him, because not only did he have documentary title, he actually had entered into possession on the basis of that documentary title for over 20 years. However, as a decision, we say, quite apart from the fact that it's a first instance decision like all of the others, it's not binding or persuasive, we also say that it was either wrong when it was delivered, or simply that the law has moved on. And the basis upon which the law has moved on, as we have stated repeatedly, is because of that quasi-judicial or fully judicial nature of the adjudication process, and our courts have now recognized that that adjudication process, and when you consider, Millards, that from the days of the Skelton decision, where our courts indicated that registration, that first registration, in fact, if you didn't claim during first registration, you would have lost your rights, even if you had documentary title. And I'm just repeating the point that why should it be any different for the squatter? Why should it be any different in principle when persons with documentary title who failed to claim during the registration process lost their rights? Yes. Millard, the court had asked my learned friend to provide the court with the reliefs that the appellants sought, and we have since received them. However, I have not. They may have come in perhaps while I was on my feet. I haven't had a chance to look at them, so I'm not sure whether it would be permitted for us to perhaps in writing or at some later point address.
I think a short written observation would be best, and so that it doesn't get left behind. Would a 7-day deadline be sufficient?
Yes, absolutely, my lord.
With, I suppose, a reluctance 7 further days to reply.
5.
5?
Did you? I misheard.
Well, I did say 7.
Oh, did you? Well, very good.
Since I heard you mutter 5.
No. I'm short of hearing.
All right. Well, a further 7 to reply.
Thank you.
Please. Yes.
Thank you, my lord.
Thank you very much.
My lord, a few points by way of reply. Taking first the interruption point, if I may, you'll be provided with a copy of the relevant provision of the Civil Code, which deals with interruption. It's 1957, and we'll email it across. But essentially, what that provides is that prescription is to be interrupted by a judicial demand. A judicial demand is not the subject of any separate definition, but underneath the
Is that 1957 of the Civil Code?
1957, at the bottom of 1957, it refers to what a judicial demand includes. And that is said to include a set-off. My learned genius scrambling around to find the bits so that I can read it out. Whilst he's doing that, our response in a nutshell is, look, bringing a claim during the adjudication process is in substance a judicial demand.
Yeah.
I'd ask your lordships to bear in mind that the Civil Code was enacted in 1957.
Sorry, bringing a claim, but what do you mean? In the LAA procedure?
Yes. So if a claim were required to be brought in the course of that process, which my learned friend describes as quasi-judicial, but may well be regarded as judicial, it is in substance a judicial demand. And
So you would accept that a paper title holder who brought a claim in the adjudication process against somebody who was claiming title by adverse possession
would interrupt.
the running of
And indeed, that's why
that makes sense.
It does make sense.
Yeah.
Yes, I do accept that. And they could also.
I'm so sorry, just to take up a moment on that. Is it before the adjudication officer, or what about the claim to where there isn't a dispute? Which is that to the recording officer?
In terms of a claim under section
8.
is to, but in the manner, it's cross-referred back to 6, which is an adjudication officer.
Section 12.
But,
Yep.
all right. But my question really is, are you saying that you need a claim once there's a dispute, or is it the claim that's made initially which may give rise to the dispute that interrupts
Well, this says, it's actually 2085, a judicial demand, I'll read it out and your lordships will get it into the course.
2085.
285, a judicial demand in proper form served upon the person whose prescription is sought to hinder, or filed and served conformably to the Code of Civil Procedure.
Where are you reading?
Creates a
I'm
civil
awfully sorry,
interruption.
just where are we reading?
I'm reading it from a provision which my lord doesn't yet have.
Oh, I'm sorry.
right.
So
So
you're
sorry.
2085.
No, I'm so sorry. Article 2085 of the Civil Code, which will be provided to your
I'm
lordships
sorry.
in due course. I'm so
All
sorry.
right, yes.
But I just wanted to just frame this by reference to the relevant provision of the Civil Code,
Yes.
which requires a judicial demand in order to create a civil interruption to be served upon the person whose prescription is sought to hinder, or filed and served conformably to the Code of Civil Procedure. And that includes seizures, set-off, interventions and oppositions, and they are considered to be judicial demands, whereas no extrajudicial demand, even when made by a notary or even signed by the party, is an interruption. Now, all of that is all perhaps very interesting, but it all predates the LAA.
Yes.
It dates back to 1957. My point is that, in substance, if the respondent and the Court of Appeal are right and a claim is needed to be brought in respect of a person acquiring, in the course of acquiring a right, a claim in the course of the adjudication process is, in substance, would give rise to a judicial demand, or might give rise to a judicial demand, which would constitute an interruption of the very right that is in the course of being acquired. And one can't safely say that it wouldn't. That's the first point.
I still just want to get clear. Is the interruption that you're talking about at the point where a claim is made to title, or where a dispute is notified to someone else?
My lord, I think it would be, if you're required to come to the table, if you like, the other person claiming title would also bring a claim. There's then a dispute, and it would be clear that the dispute involves, if you like, a challenge to the right that's being asserted by the squatter. So it would be at the point at which the dispute was raised, I suppose.
I mean, the difficulty with this is that the adjudication process starts.
Yes.
The paper title holder applies for registration. That's not served on anyone except the adjudication officer. The person claiming a possessory title does nothing.
Well, if they do
So,
nothing, then there's
Is
perhaps
that
no
a
scope.
judicial, is that an interruption?
On that language, probably not, because it's required
Yes,
to be
right.
a demand to be served. I think the substance of this is the paper title owner needs to make it clear that they are not accepting your assertion of possessory title. That's the judicial demand. They're trying to interrupt by saying, get out.
Yes, well, I follow that, but it's not, yes.
So it's slightly clunky, I accept, but that we can't safely assume that a judicial demand wouldn't arise in the course of the adjudication process. And secondly, we also say that if we were required to come to the table and assert our right, which is not yet crystallised into an interest, there are other ways of stopping us, because I'd ask your lordships to keep in mind, as I'm sure you will, the fact that occupation has to be sole and continuous, so they could just demolish fences or send someone in to occupy the land that we were occupying. So in practical terms, our occupation could be interrupted, if you like, on the ground, even if there isn't a judicial interruption for the purposes of the Civil Code. You follow? So it's the point about, putting your head above the parapet and exposing your position before you've crystallised your right.
But, I mean, you would be entitled to apply, wouldn't you? And seek at any rate a provisional.
You would, but would it be
Site
safe to
certificate.
do so? I mean, that was a
But then
decision
you've
you
got a
have to make.
contest, haven't you?
And you've got a contest, but you haven't been able
And
to
then that will
interest.
be resolved in the process.
That's right, but in the absence, if you are falling short of the requisite period,
Yes.
it would be safer, I suggest.
But is this law
For you to keep your
there
head
to
down.
protect squatters who haven't been there long enough to get possessory title?
Not simply, no. I mean, as per, and whilst I fully accept that 1925 legislation isn't on all fours and is different, what we do rely on the Law Commission report for is the language and the carve-out for overriding interest, which applies with equal vigour to the St Lucian legislation. The policy is there to protect the rights which are the draftsman consciously decided to protect for reasons which include the fact that they arise informally, may not be known about, might be short-term, and so on.
Well, that's back to Lord Jauncey.
That's back to Lord
Yeah,
Johnson.
really.
Exactly. But that's the interruption point. If I
Okay, yeah.
so far as so that's that point. My learned friend referred to section 28E when he was taken to that, and accepted that particular section requires you to look at the underlying laws so far as the charges are concerned. That acknowledgement, I say, supports our position that the Act is not requiring you to ignore the underlying law. In fact, it coexists with the existing law. And if, one provision of Section 28 is to be acknowledged as having that effect, then why would that not apply across the board? And so to subsection F and G. And we say it does because you have to look at the underlying civil code and the search which would need to be carried out, which I think my learned friend acknowledged would need to be carried out in relation to subsection E, is equally applicable to F and G.
Do we know what 28A at the time of first registration, why is that put in?
I haven't been able to bottom that out, my lord. If I can, I will, although not before 4 o'clock.
But it seems to reflect a similar provision in the English Land Registration Act that exempts or used to exempt easements.
Indeed,
Yeah.
yes. And on that point, whilst it's on my mind, I was asked before the lunchtime adjournment whether overriding interests were carried across into the 2002 Act, and the answer to that is yes. They are in Schedule 2, I think it is, rights in actual occupation, but it's not precisely the same language. If I can next just briefly touch on Joseph, which my learned friend made reference to, and the quote there is the finding that it would make a complete nonsense of the scheme if time wasn't interrupted. Well, I remind your lordships that wasn't an overriding interest case. My learned friend then invites you to construe section 6.8 as mandating claims on the basis of the need for finality and certainty. But, my lord, our response to that is, well, finality and certainty in this legislation takes expressly subject to section 28 and overriding interests, in respect of which the court has preserved its jurisdiction under section 115. And if I may adopt my Lord Briggs's point, that after 30 years has passed, that certainty and finality is blown wide open. There's not sufficient, we say, obvious policy justification for a temporary certainty for the first 30-year period. My Lord, Section 98, much is made in my learned friend's written case about the authorities which deal with Section 98, and he says that really we're doing here is extending the principle to overriding interest that the court has recognised applies to Section 98, namely rectification. Well, our response to that, my Lord, it's really a wider principle of finality that's thought to be extrapolated from those cases. Our response to that is this is not a situation where a civil claim, a rectification, is being used to circumvent or relitigate a matter which has already been determined. Section 98 is the section which provides a remedy where the problem was with the registration process. And that's clear from the Adural case, which I took your lordships to. It's not the section which overriding interests are dealing with, which in respect of which the court's jurisdiction is expressly separately preserved by Section 115. Rectification, my lords, is completely different as a concept from overriding interest, and that was recognised in the Law Commission passage that I took your lordships to. They both create cracks in the mirror, but they're different cracks. And to construe, I suppose, rectification in the way suggested by my learned friend would involve both expanding the rectification jurisdiction and reading down the language of Section 28. Turning then to Graham Davies, I think your lordships have my submissions in relation to that. What Lord Chauncey was doing was looking at the purpose of Section 28. He had his eye firmly on Section 28 and what it was seeking to do. He referred to the character of rights which it protected, and he looked at the effect of personal service. Now, that effect applies to all of the overriding interests in the list, not simply F and G, across the board. And none of that is dependent on the proviso. If one looks at the reasoning, it's quite clear, just simply from how it's set out, that the first part deals with Section 28 and the purpose and service, and then the reference to Section 15 appears after that conclusion's been drawn. So Lord Chauncey wasn't focusing on Section 15 and the proviso in order to form his view. He was simply saying in relation to Section 15 that there had been no determination and therefore they hadn't lost the right to proceed through the courts. No res judicata point, no problem. So far as George and Guy is concerned, my lords...
Can I just... Yes. It's right, isn't it, that the proviso to Section 15.2 in the Antiguan legislation was not restricted to overriding interests?
No, it wasn't.
It would apply to any challenge.
That's right, yeah. It wasn't restricted to overriding interests. Yes.
I mean, I only ask that because Lord Chauncey begins this paragraph at the foot of page 2309 by saying the scheme of the 75 legislation was that an interest registered under the Title by Registration Act, that's the old Registration Act, would be registered in the 75 Land Register without alteration, but that such registration would not affect the existence of overriding interests. But would it have affected other interests?
Well, the reason it wouldn't affect the existence of overriding interest is because of the effect of Section 28.
Yes, I see. Okay.
Well, and the predecessor section regarding the earlier Land Registration Act.
Exactly. So what he's doing there when he's referring to the scheme, he's just describing what the scheme does, no more than that. But then he goes on squarely to focus on what Section 28 is designed to achieve and the policy purpose line behind it.
Yes, I see. All right.
I'll move on to George and Guy. We accept that the legislative scheme in George and Guy is not entirely on all fours. There are different provisions. I've taken your lordships the passages in that judgment which refer to sometimes it having been dealt with by overriding interests. That's what we have here. But at 2211, which is the paragraph dealing with the four things, that's paragraph 32, suggests that in relation to RPLA, TRA does at least four things. We say that those four things can be extracted similarly from the St. Lucian legislation and the Civil Code when looked at in combination. So firstly, it affirms the RPLA and the rights given to squatters. Well, pausing there, so does the LRA and the LAA, because they're a reference to the Civil Code. Secondly, it expressly provides that those rights are exception. Well, so too here with section 28. Thirdly, it provides a process whereby a squatter is allowed the sensible option of converting into a tangible and registered certificate. Well, we say so too here because of the mechanisms you find in section 115, section 80 and section 94-95, which is the process by which you get the registered title. And fourthly, it clothes any certificate with the same blanket of indefeasibility. Well, so too here, because you've got the benefit of a certificate and you take it forward. So those four things are precisely, not exactly used in the same way, but in substance to be found here. My Lord...
Except perhaps the words is allowed, the sensible option, because that requires toning down the obligation to specify your claim once notified by the adjudication officer into an option. I mean, well, you may say that's what it means in practice, but it's a slight straining of the language of the St. Lucian statute.
I read the process whereby a squatter is allowed the sensible option to be the process by which you can apply to the registrar for registration of the title you've acquired. Under section 94. Yes, so you allow, but you don't have to. It provides you with the option. If you want to equip yourself with the sword, you can go and get yourself a registered title, as long as you've got the claim or the order of the court, which we say under section 80 would require the registrar to give effect to. The point is the mechanisms exist.
I think you did tell us that the term interest in land was defined.
Yes, interest in land is defined in the LAA, right at the beginning, I think.
Yes.
I'll get the reference for you. It's on page 2022, I think. Yes. Includes any right or other interest in or over land which is capable of being recorded under the provisions of the Act. And the Act is...
Which Act?
Is... Well, is not.
Sorry, which Act is this?
Well, that's what I'm looking for that.
Is this the Dominican Act?
No, this is our Land Adjudication Act at page 2022.
Sorry.
And the definition, my lord, of interest in land.
Yeah.
But it doesn't make it quite clear what the Act is intended to be. It says this Act at the front of paragraph section 2 in this Act, but then it refers to the Act more generally, without a definition featuring.
That's right.
Yes, and both the LRA and the LA obviously act, so they both are capable of qualifying. Recorded. One would have thought it's this Act, but...
Yes.
So the should be substituted for this.
But you would accept, would you, that includes an inchoate claim to adverse possession?
Any right. The words are general. I think I have to accept that, yes. So then, two further...
Yeah, and sorry, just so I get it clear in my mind. So such an inchoate claim is capable of being recorded under the provisions of this Act, I think under section 16(1)(d), isn't it, as provisional title?
It is, although, can we go to section 16(1)(d)?
Sure, I'm just trying to see how it fits together.
It may be recorded.
Yeah.
Yes.
is capable of being recorded.
Yes.
So that would capture Section 6, provisional title under Section 16(1)(d.
Yes, it would.
Yeah.
But dealing, while we're at Section 16, if I may, to deal with a point that it was Lord Stevens made about the one-year squatter, or it's actually my Lord Briggs. Going back to 16(1)(a), 2, I think it was, and it was the paper title point. If a one-year squatter pops up, what's the effect of that? The answer, I think, to that is it has to be a person who's acquired or in the course of acquiring and who would succeed in maintaining the title. So this points against the one-year squatter popping up at all, because back to my point on interruption or being able to be ousted, if they were to pop their head above the parapet, you could stop them from being a person in the course of acquiring pretty quickly.
Well, that's where the dispute would be resolved, wouldn't it?
Yeah.
And the resolution might be, well, you've only been there 5 years, so you haven't got anything.
And would that be resolution under Section 15?
Yeah.
And the dispute, if a dispute were raised by such a person, but I maintain the line that it would be very inadvisable for such a person without the crystallised claim to, because they're never going to win. But yes, if there was a dispute, it would be Section 15.
So the person in the penultimate line, person claiming the land or any part thereof, is the person who is acquiring a title. Is that right?
A person has a good title and no other person can beat it, is essentially what Roman numeral 2 is dealing with. Yes, and that person being the first person, the person with a good title.
Does it follow that most of the references in Section 16 are to the recording officer? That we're mainly talking about a non-contentious process here, because it gets to the adjudication.
Yes,
officer
if there's a
some kind of
dispute. Yes. And that goes to
I did look and see what their different duties were, but I think that's right.
That's right. So you have different hierarchies of roles. So recording officer, it's non-contentious, my lord's right. And then if there's a dispute, then it goes to the adjudication officer.
Yeah, that's reminded me now why, and forgive me, I mangled my question to you about the point at which a claim would interrupt the prescription process.
Yes.
And that it's Section 16(1) that I had in mind. That actually the initial claim, I think, goes to the recording officer.
Yes, and that wouldn't, I would have thought, constitute a judicial demand.
No.
It's not. It doesn't in substance hit the target, which is a person making it clear to the other party claiming that they don't accept the right being claimed.
But, I'm sorry. Well, I mean, you say that someone who's well advised in and is squatting wouldn't put their head above the parapet, but I mean, it may not be up to them whether they put their head above the parapet. The recording officer may have information showing that there is someone squatting on the land, and so they may not be satisfied that they can record the paper owner as the proprietor.
But,
and wouldn't they
yes.
then have to refer the matter over for adjudication under Section 15?
If they knew who the person was, that might flush out a claim, which would need to be resolved, and if then resolved, it would be part of the adjudication process, which would result in a certificate. And if that person had been forced to the table, if you like, the only recourse would be under Section 98. I accept that. That's a different process, or a different set of circumstances to what we have here, which is no claim having been brought or flushed out. And back to, I think before lunch, I said that the presumed policy purpose for empowering the adjudication officer to decide claims is to mop up things as much as possible and to reduce the burden on the court in due course. But it's not necessarily the fact that it's quasi-judicial doesn't remove any judicial ability of the court in due course, which is expressly preserved by 115. Simply because it's simply because you give powers to the registrar, in other words, doesn't mean that everything has to be dealt with by the registrar at one point in time.
Yes. Just on the question of when a claim of some description interrupts the prescription process,
Yes.
I understand your answer that the initial claim under Section 16 to be registered doesn't do so.
Yes.
But if it appears to the recording officer that someone may be acquiring possession, so they refer matters under Section 15 to the adjudication officer, does such reference constitute then a judicial claim for the purposes of interrupting prescription, or would one look to the processes adopted by the adjudication officer, whether they then serve notice on relevant people to, if you like, bring them to the table for resolution of the dispute.
My Lord, I would say that the reference would in substance constitute, because it would, and the reason for that is it's a dispute at that point in time.
Yes.
So there's one person saying I own it, another person saying no, you, and then effectively there is a conflict as to ownership, which the party doesn't accept the squatter being there, and that's what the judicial demand is
And time
to do with.
running during the currency
Quite.
of the litigation.
Yes.
I'm sorry for bringing you back to it, but 4 lines up from the bottom of 16A, Roman numeral 2, you get, and that he would succeed.
Yes.
The he refers back to no other person, or does it refer back to the person?
No, any other person.
No other person has acquired in the course of riding, and that he would succeed against any other person. Sorry, the he would succeed refers, you're quite right, my lord, back to the person with the good title.
With a good title,
Yeah.
right? Okay.
That's how I think it must read, because somebody's got good title, no other person is challenging it. Sorry, can I just read this again before I accept that? That's good title.
I mean, yes, I see.
Well, it's not.
I think it's against a hypothetical person, isn't it?
Yes, it might be someone that might hypothetically turn up and say, I've got a better paper title, but nonetheless, the recording officer might be satisfied, well, there you haven't. It's clear who's got the paper title.
Yes.
Would give some content to that.
It might arise if there appeared that to be some defect in the paper title.
Yes.
Say, so I'm sure you've got other points you want to...
One or two, I think, two final points. Section 80, 2383. Is that 2383? No.
2077.
I'm so grateful. 2077.
Section 80.
880, yeah.
Sorry.
You have my submissions on this. I think the width of the language, regardless of whether it appears in Part 7, and I note the context, but it covers the acquisition of land from one to another by operation of law. And the language is wide. Where any person has become entitled to any land under any law by virtue of any order. Pausing there, that would include an order under Section 115. The registrar shall, on the application, register as proprietor. The effect of 2130A of the Civil Code is that title may be acquired, quote, is a quote. There's no reason we say why 80 wouldn't cover that. In fact, there's every reason why it should. I'll skip over Strand Securities. I mean, I don't rely on the 1925 Act in relation to anything other than policy. And my lords, you will have noted in our, I didn't refer to the witness evidence of the defendant in opening. I perhaps should have, but I just ask you to note that it's there and it sets out the case below as to occupation. And that's at page 1203.
Thank you, Ms.
And I just turn to my junior, in case I've missed anything. Yeah.
Ms. Stacey, one very short question. The relevant provisions of the Civil Code provided for enunciation of a prescriptive claim.
Yes.
Both either completely but not prospectively,
Yes.
and in relation to chunks of time, and it could be either express or tacit. I'm not whether sure whether the submission's being made against you, but in case it is, why would not a failure to claim in a statutory regime which enabled or indeed commanded you to claim be a tacit renunciation of such time-based prescription of you'd acquired up until that time?
Because, my lord, it depends on the circumstances. One would have to investigate the underlying position. One can't assume that it's a tacit.
Right.
Yeah, it might be, but there's nothing to that that points to that in this case, and particularly in circumstances where there was, as I said, an unresolved factual dispute about why he didn't claim.
Yeah, thank you.
Great.
On what may be the last or one of the last appeals since Lucia, this has been a most challenging and stimulating day, for which we are extremely grateful to counsel on both sides and their backup teams who've worked on really excellent written and oral submissions. And it will come as no surprise to learn that the board will take time to consider what advice they humbly tender to His Majesty.
I'm grateful. Many thanks.